Hello, welcome to today's Law Awareness Weeks at CDC 2020, The Law and Me, Stronger Together, organized by Law Society Pro Bono Services, the 5 Community Development Councils, supported by People's Association, National University of Singapore Faculty of Law, Singapore Management University School of Law, Singapore University of Social Sciences, and Singapore Corporate Counsel Association. I am Regana, and I'm your host today on Advanced Legal Planning. Now, before we get on with the webinar and introduce our speaker for today, just some housekeeping before we get started. Relevant materials for today's talk can be downloaded from the handout section, which you can see on your screen. If you're using a mobile phone or a tablet, the icons should appear on the top right-hand corner. If you're using a computer, you should see the icons on the right. Please download these useful materials before the end of the talk, and I will remind you once again later. Feel free to ask any questions during the webinar. You can type them into the questions section and click send. Your questions will only be seen by the organizer. We will do our best to address them during the webinar or at the Q&A session. Please note that the discussion today or any material provided in this webinar is not intended to substitute or constitute as professional legal advice. You should always consult a lawyer if you require specific legal advice. Now, with that done, speaking about lawyers, today with us, we have Mr. Tan Shen Kiat. Let me introduce him before he says a few words. Now, Shen Kiat is a qualified lawyer in Singapore since 2015 and a founder of Kith and Kin Law Corporation. His expertise lies in private client matters, especially in areas of STEM, which stands for succession, trusts, estates, and mental capacity. He is currently one of the emerging figures in the mental capacity and practice space. He currently sits at the Law Society Probate and Succession Committee and the Agency of Integrated Care Institutional Review Board. Now, Shen also teaches at SUSS and SASW, which is the Singapore Association of Social Workers. He is very passionate about raising the legal literacy levels in the society and often volunteers with LSPBS. It gives me great pleasure to have you today here, SK. Thank you for taking time out, considering you just had a baby. Congratulations about that. And thank you for joining us on a very important topic.
Yeah, thanks, Regana. Thanks for having me and for giving me such a generous introduction. It's my pleasure to be here with you and with everyone who's watching this webinar today.
Thank you. So today, our goal is that you, our audience, will come away with a clearer understanding of how to help yourself, your loved ones, your family members plan their future, plan their affairs, right, Shen Kiat, after their passing. We will also be talking about making early choices, tough decisions for situations that, you might not even have a say in the future. So while you may be currently in good health, it is very hard to imagine that a time where you are unable to express your wishes about your health care for yourself or even for a loved one. So with advanced legal planning, you're able to plan ahead and make your wishes known earlier and also make life easier for your family members. I think that is very important. So now for the topic at hand, we'll be covering 4 topics today with Shen Kiat here. Firstly is what is the lasting power of attorney and how to make it. Secondly, deputyship. Thirdly, advanced care medical directive. And lastly, how to make a will. We'll be covering quite a lot of ground in a very short time. So We want to
True.
get through this, and we also want to answer all the questions of our attendees. We have put together 2 scenarios at the end where Shenket will be giving his legal, professional, and personal advice. So let's get started with the
Information.
information. Yes, thank you, SK. So let's get started with a very, very simple question. All right. What is a lasting power of attorney, and what's the purpose of it?
Yeah, so thanks Regana for the question. I think in a nutshell, lasting power of attorney is a legal document that a person can put in place in advance to decide on who should be their proxy decision makers in the event whereby they lack mental capacity and the institutions that normally recognize their autonomy to act refuses to transact with them, right? Transact with this person directly. So the LPA is a legal document that is only utilized when the person is both alive and lack capacity. So these two are very key points, right? And and also the LPA is also used mainly for the donor's benefit. So in a nutshell, it can be said that with the LPA, the proxy decision maker, sometimes I'll call these proxy decision makers caregivers, they will be allowed to use the donor's resources to maintain or even improve the donor's quality of life. In a nutshell, let's say for example, yeah, so a very quick example. So my dad appointed me to be his donee. I told my dad if he relies on these poor millennials resources to take care of him, at best I may be able to let him stay at a B2 class restructured hospital. But he has his own insurance policy, he worked so hard in his life, he's one of the better off boomers. I said, I can use your resources to bump you out in the A-class hospital, A-class ward in a private hospital, right? If I have the power to utilize his resources. So this is what I meant by using the donor's resources to maintain or improve the donor's quality of life.
Okay, I understand. So what happens in the event someone's quite stubborn? I know some friends, family members, parents who say, I don't want to do LPA. You know, you know, Asians, we have
Yeah.
this pantan, we're not comfortable talking about death.
Yeah.
So what happens if one chooses not to do or not to get an LPA?
Well, I suppose if the person remains healthy for the rest of his life and doesn't lose capacity, then not having an LPA, right, essentially wouldn't make a difference to this person. But the fact of the matter is that the scenarios whereby LPA will be activated, they're actually quite common scenarios that I see in my day-to-day work, right? So for example, elderly couple, their children got married, they moved out of the house, they decided, hey, my 5-room flat is too big now because my children has, got married and moved out, and the husband don't always help out with the housework, so let's move to a smaller, flat, right? And the process of shifting from a 5-room to maybe a 4-room or a 3-room flat, maybe one party suddenly lost capacity, right? It could be due to an accident, it could be due to an illness such as a stroke, which I'm sure we recognize that it happens, right, to people. And in that situation, well, the sale of the house will be quite straightforward. The sale of the 5-room flat will be quite straightforward because the money will go back to the CPF, will go back to the bank accounts. But then the caregiver, aka the loved ones, will then have trouble to get the banks and CPF to release the monies for the purchase of the new place. So most of the time when people come to me, that's because they had this transaction they needed to complete within a time period, right? Especially for property transactions whereby there is a deadline to complete a transaction, or else there will be late penalty fees payable, right? So yeah, so in these cases, people realize they need LPA, but there wasn't LPA done, and that's where we will have to go to the court and ask the court to appoint, someone, right, a volunteer, normally a next of kin, to be the personal representative of this person, and that process is generally a lot more onerous, more costly than putting an LPA in place.
Okay, and usually it's always a next of kin that's appointed. I mean, by the courts.
That's right. Most of the time, that's right.
Okay, thank you very much for that. So at least we sort of understand what an LPA is now. The next important question actually is actually before I go on, we have a very interesting question coming in from the audience, Shinket.
All
The
right.
first one for today. So someone's asked, assuming that he or she does an LPA, who decides whether he or she loses mental capacity so that my LPA is activated? So let me repeat it again. Assuming I do an LPA, who decides whether I lose mental capacity so that my LPA is activated? I'm concerned that my LPA may be activated when I'm still mentally fine. So I think I sort
Yeah,
of
that's
understand. Yeah.
yeah,
Go ahead, Chinket.
yeah. That's a great question. I mean, that's a great question. I think the person who asked that question probably realizes that mental capacity exists in the spectrum. It's not something that you have or you don't, so straightforward, right? Someone who may not have the capacity to manage large amounts of money, they might have the capacity to manage small amounts of money, right? And also to be able to deal with their own personal welfare decisions as well. But in any case, to activate LPA, a medical report is required. And so the medical report needs to be from a qualified medical practitioner in Singapore. Inside the medical report, certain details needs to be present. So first and foremost, the medical report needs to state whether the donor lack of capacity, is it permanent or temporary? Right? If it's temporary, then the medical report's validity is for about 6 months. So any decisions that to be made on behalf of the donor past the 6-month period, a new medical report will be required, right? So that's one. The second detail will be to what extent is a lack of mental capacity. So as mentioned earlier, I have clients who can't manage large insurance payouts that are given to them because of an accident, right? Like 2 million, 3 million. But if you give them $10, $20 to spend at the hawker center or at the supermarket, they're still able to do so. So the medical report will also need to state what is the extent of the lack of capacity, right? And so with that medical report, then your donee will be able to approach whichever particular institution and carry out the action that is necessary in order to maintain the donor's welfare. And that's not the end of the story. I've seen situations where the donors recover, right? So in a sense, it's not activation of LPA may not be the end or be all of the story. You can actually get a medical report to say that you have recovered and go back to the same institution, for example, the banks, right? And regain control over your own affairs. So in that sense, the LPA is very fluid with regards to how it's activated or deactivated, and all these things needs to be supported by a well-written medical report by a qualified medical practitioner in Singapore.
Okay, it's a quite a fluid process in a way. So I'm just actually wanted to ask you, so the medical report lasts for 6 months, you were saying. So every 6 months, would the person would have to go in and have that check done, or how long does it take before?
So if the medical report indicates the lack of capacity is temporary, right? So there's some people who are stroke patients. They might not have a capacity right at the beginning, but they will slowly regain their cognitive functioning with therapy, right, and rehabilitation. So in that sense, the medical report that is used to state that they lack capacity, it has a validity period of 6 months. Whereas if the lack of capacity is permanent in nature, right? So for some of my clients who are intellectually disabled, right? So the medical report in that sense does not have an expiry date, and it can be used on almost any occasions.
Okay, thank you very much, SK. So now we know what an LPA is. Now let's take a look on how to make an LPA. So SK, I'm sure I'm going to ask you this question. How easy or how difficult is it to make an LPA, and bring us through the process?
Sure. I think fundamentally, if talking about administrative process, right, of getting the LPA documentation done, getting a certificate issuer to stamp on the document, make sure that the donors and donees are properly appraised of what's happening, that's not difficult. I mean, lawyers, doctors, psychiatrists, they are everywhere. It's not difficult to get them. The forms are readily available online. You can either fill it out yourself, or you can get one of the professionals to do a walkthrough with you and fill it out along the way. I think the most difficult part that I've seen my clients struggle with before they make an LPA is really trying to figure out who should be their donees, right? As part of the who do they choose? Are they doing any value signaling based on who they choose, right? And for these characters that they have decided to be involved in their LPA, what sort of powers to give to them? How should they manage these powers, right? So I think back to this question, how to make an LPA, I think first and foremost, have a conversation with your donees, potential donees first, right? To make sure they know what they're doing, to make sure that they are willing to take out this responsibility, to not make that let them know that they have fiduciary duties as well, right? It's not suka suka, kind of situation. And then after that, um, find a certificate issuer who could sit all of you down and explain the ins and outs of the LPA, and then fill out the form and do the certificate issuing on your behalf, right? And hopefully the same person will be able to submit the document for registration with a lasting power of attorney. Sorry, with the Office of Public Guardian. So that's
Oh,
the interesting part about the LPA. It needs to be registered for it to be valid, unlike some other legal documents like a will, for example.
okay, very interesting. Actually, we have a good question that's come in about the donee. So this person has asked, or the audience has asked, do I need to inform my intended donee that I've made them a donee in my LPA? And I'm assuming it's yes, right? So Shenket, would you like to answer that question?
Yeah, I mean, Regana, you already answered the question. The answer is yes, and I second Regana's answer, right? Really from the perspective of that the donees can't be appointed without signing on the document itself, right? So by the very act of signing on the LPA document, the donees will need to be notified. I'm sure nobody will sign any legal documents blindly, right? In that sense. Whereas I suppose if this person who's asking this question is thinking about wills, right? A will, you can choose who should be your executors, but they may not be the no, because nobody else needs to sign the document other than a testator, right? But that's not true for the LPA. Whoever that you appoint, they need to sign. They need to be notified.
And I'm assuming it's quite a big responsibility to be a donee. And moving forward, I actually, there's a couple of questions coming in now. Now, once if someone has filled the relevant forms, which is Form
Mm,
1 and Form 2 on the
yeah,
OPG website,
yeah.
how do I get it certified? How do I get my
Oh,
LPA certified?
yeah. So OPG has a list of certificate issuers, right? So all practicing lawyers, they can be your certificate issuers. So you can basically walk to any of your neighborhood law firms or those in the CBD, or just run a Google search. You can find anyone to do a certificate issuing for you. There's doctors as well, but not all doctors can certify an LPA. So do check, make a check on the OPG website. They have a list of accredited doctors. So it's good to best then check with the particular clinic, right, whether they still offer that service or not. Because from my understanding, some doctors only carry out that certificate issuing service for their old clients, for familiar clients. They may not necessarily do it for a stranger who does not live in their neighborhood where the clinic is
Ah,
based. So that's something
okay.
you should call and check. The third certificate issuer would be the psychiatrist, right? I would advise people who may have a loved one who they deem to have borderline capacity, right? So for example, the onset of dementia, to perhaps approach a psychiatrist instead of a doctor or a lawyer to get the LPA done, because a psychiatrist will be able to do a more thorough mental capacity assessment and certificate issuing at the same time, two in one, right? Whereas
Ah, okay.
the lawyers may demand or may request for a medical report to be done. So you have an additional uh, administrative, hurdle to cross, right? So I think each certificate issuer have their own purpose, and depending on your needs, you should find the best one that suits you.
And for this certificate issuing and for, is there any cost involved? Uh,
Yeah, So the certificate issuing cost basically will be the CI fees, right? The certificate issuer fees that you will pay to whoever is the professional, right? Okay, not all of their legal professional, right? Whoever are the professionals, right? Who's doing the certificate issuing. And do bear in mind that different CIs, they also have different I suppose service standards, right? Some need the client to prepare the forms and they will just certify on the document. So a bit more like a conveyor belt system. Other circuit issuers will sit the donors down and make sure that they know what they are doing. They are not under any duress, undue influence. They know what powers they are giving away. Make sure that they prepare a schedule of assets so that the donors know what they are managing. So there's more consultation involved. And obviously we have the psychiatrists, right, who a bit more, they do something a bit more niche that the lawyers may not be able to do. So yeah.
Okay, I hope that answered audience's question about roughly how much, because I don't think we can put a cost because it might vary
Yeah,
from
it
what
probably
I'm
will be a
hearing from
range.
you,
That's right.
a range. Okay, so I do up the form, I filled it up, I got all the signatures. What do I do then? How do I register my LPA application?
Right. So you can submit a LPA application at the Office of Public Guardian's main office, which is at Enabling Village, somewhere near Red Hill. You can either submit by hand or you can, I suppose, mail it in. If you want to mail it in yourself, if your certificate issuer does not offer you a service, I'll suggest that you do registered post, right?
Mm.
Yeah, so that there will be no doubt to anyone that you have mailed out the document to that particular recipient.
Yeah, that's great advice. I have another question coming in actually about the LPA. If my father makes me a donee, does he have to
Yeah,
inform my siblings? And can my sibling dispute me as a donee? That's a great question, actually, Chinket. So,
yeah,
what's
yeah,
your take
yeah.
on this?
It's a great question. It's also a difficult question because it's at one part it sounds like it's a legal question, but the other part is really not a legal question. No, I think from a legal point of view, the donor is not and the donee, appointed donee, they are not required to inform anyone that the LP has been made, right? So that will not affect the formality of registering an LPA. However, obviously, the idea of putting an LP in place is to ensure that the caregiving process for the donor is as seamless as possible, is as frictionless as possible. So if you anticipate that a sibling may potentially cause trouble down the road, perhaps, and we know that the donor is healthy and well, then perhaps it may be worthwhile, and I say this as a value judgment, personal opinion, to actually make sure that all relevant parties are informed as part of the process of making the LPA. In fact, under the code of practice, which is this code of conduct, in this document that the OPG, Office of Public Guardian, has put out, it did mention that the donees, when making a decision for the donor, needs to consult all relevant parties, including family members who are not donees. So in that sense, you are basically, as a appointed donee, you are carrying out your duties in advance, right? By talking to these parties as well. I understand that, well, I'm an advocate for transparency, especially when the donor is healthy. I do understand that there might be very unique, very niche situations where transparency may not work for the family. So I think at the end of the day, you have to see what is your own family situation, right? To see whether transparency works best or not.
I think it's having that conversation because it's a family thing. It's quite
Yeah,
important. Thank you very
absolutely,
much for that,
absolutely.
Shinket. I'm going to ask one more question before we move on the next slide, because I think LPA seems to be a hot topic. Um,
Yeah.
can I appoint two donees instead of just one? If so, what happens if my LPA is activated and my two donees can't agree between themselves on my care?
Great question. I get this very often. It's very interesting, right? I always tell clients, look, I mean, are you married? You know, if you're married, do you not have disputes with your spouse? You know, if you're somebody else's child, do you not argue your parents? Do you make up? Right? Do you reconcile? What's the process of you know, reconciling with your loved ones, right? I think my point that I want to make is that if you have at least two donis, conflicts will definitely occur, right? The question is, does these two donis, I call that A and B, right? Doni A and Doni B, do they have a dispute resolution mechanism process, right, between the both of them? And fundamentally, I think donis disagree because they can't come to a consensus on what is in the best interest of the donor, right? They can't come to a consensus on what's the best interest of the donor. And oftentimes that happens because the donor does not leave explicit instructions on what is considered to be his best interest, right? And because due to the lack of instructions, both Doni and Doni B, because they love donor, if they love the donor, right? They have to then put themselves in the shoes of the donor and start to consider what would they do if they were in the donor's position, which obviously, while their means, I mean, they come from a source where both of them love the donors, but they may have different outcomes, right, regards to the decisions that they want to make. So I think one way to minimize conflicts between donor A and donor B is really to maybe do an advanced care planning workbook, to put down some advanced decisions on how certain care should be like, do you want life-sustaining treatment or not, so that your donors, right, they are basically a personal extension of the autonomy of the donor. They are extension of the personal autonomy of the donor. They are not, you know, being creative about the care of the donor, right? So that really helps a lot of my clients when they want to make decisions for their donor, to know in advance what they want. So if you have at least one donor to appoint, I'm happy for you. If you have two, even that's better than one. If you have three, you can choose two donors and one replacement, right? If you have four, I think that's a situation where, you know, you have to think, is it many hands make light work versus too many cooks spoil the broth, right? So I just, at this point, I just have one final point to make. If you have two donors and one replacement, and your two donors are allowed, that means you allow them to make decisions jointly and severally, the replacement donor will be able to come in and replace either donor A or donor B who is unable to act, maybe because they lose mental capacity first, maybe because they pass away in advance, right? However, if you appoint donor A and donor B to act jointly on your behalf, if you appoint donor A and donor B to act jointly on your behalf, that means that the replacement donor C, when he or she has to come in, C will replace both A and B, right? C will replace both A and B, and C will not replace either A or B and act jointly with the other party. So that's something that most people who DIY their own LPAs, they would not have gotten this part right.
Or they
So I
usually
thought
would
I'd just
tend to miss
take
that
the
out.
opportunity to
Oh,
pace out in
thank you
advance.
for that
Yeah.
clarification. I didn't know that either, because well, it does make sense if it's a joint decision and both of them can't act on it, the replacement has to take both
That's right.
responsibilities.
That's right. Because
Very
B cannot act with
interesting.
A anymore, right? And B
Yes,
only can act with A, you know. So C cannot come here and replace A and act with B. So that's the reasoning, at least from Office of Public Guardian. Yeah.
I understand.
So
Okay, lots of questions coming in, but we have to move to our next slide, which is on mental capacity and deputyship. So, first of all, SK, could you explain the concept of mental capacity and what happens when a person lacks mental capacity to make decision for himself or herself?
so I think in our everyday life, every decision that we make requires some form of capacity, right? What do you want to have for lunch? What sort of social activities you want to engage in? At the higher level, what sort of investments you want to make, who you want to marry, even though some people may say love is blind, so that may not require much capacity. So yeah, so depending on the kind of action that a person wants to take, different levels of capacity will be required of the person. And sometimes you might find that due to some accident that result in a brain injury due to some underlying medical issues, right? That particular capacity or the cognitive ability may not be present at that point in time when a particular decision needs to be made. And that would be when, I suppose, the person who needs to make the decision will then lose their autonomy to be recognized, to have their decisions recognized by whichever institutions that they are engaging with. And the law provides for a proper process where legal representatives can be appointed to represent this person to make a specific decision that they otherwise would not be able to do so by themselves. We have spoken about LPA earlier. So LPA basically allows people when they're healthy and well to choose who they should appoint. So no issues with the registration if the person still has mental capacity. However, all hope is not lost if the LPA is not made, because we do have a secondary process called the deputyship, right? So the deputyship, in a sense, basically mimics the LPA. It allows for a proxy decision maker to be made as well on behalf of someone who lacks capacity. However, this person is chosen by the court, is appointed by the court, is appointed by a series of judges that you have no relationship with, right? It's not decided by the donor. And as such, because it's decided by an independent third party who wants to do things in a fair and transparent way, a lot of questions will be asked in this process, right? So for example, whoever wants to be appointed as the deputy, which is AKA the proxy decision maker under a deputyship, they will need to furnish a lot of documentary evidence, for example, their income tax returns, right? We need to make sure that they're financially okay, they are not up to anything funny. We need to make sure that they are not bankrupt. We need to make sure that they have a proper relationship, right, with the donor. We need to come up with care plans. So it's a lot more onerous in that sense, but only because flexibility and accountability, they are different sides of the coin. For LPA, there's more focus on flexibility than accountability. For deputyship, there's a lot more focus and emphasis placed on accountability as opposed to flexibility. And yeah, so in a nutshell, for people who have not lost their capacity, go make an LPA. For those who have already lost capacity, then deputyship may be something that a loved ones needs to look at.
So it's a bigger responsibility to be a deputy, because you are really taking care from A to Z of that person. So I actually have a question before I move on. So what happens if no suitable person can be found to be a deputy or a donee? What happens in this event?
Very good question. I think first and foremost, we do not want to apply for a deputyship until there's a real need, right? Until there's a very real need. So most of the time, the need will arises when a person wants to carry out a particular transaction and is prevented from doing so. For example, withdrawing money from a bank, and the bank officer stops you from doing so because he thinks that you're suffering from exhibiting some sort of dementia and what's not, right? Or you want to sell your place and buy a house, but for some reason the people who you are transacting with believe that you don't have capacity and doesn't want to deal with you. Or you could be in a hospital, right? Because you suffer from an illness and sudden illness and you lack capacity and you want to withdraw your insurance monies and what's not, but nobody allows you to do so. So that's the starting point, right, of when a deputyship will be required. But not everybody goes through that. So in that sense, if you don't meet any of these pain points, you're not likely to think of a deputyship. But for those who met these pain points and they don't have anybody to appoint, the government 2 years ago, they introduced this scheme called Professional Deputies and Donees scheme. It's basically a scheme where they provided some training to a bunch of professionals that comes from mainly 7 regulated classes of professions. I think they are like doctors, nurses, allied health workers, accountants, doctors, social workers, and lawyers, right? So these are properly accredited professional deputies and donees. They hold a license with Office of Public Guardian. They are also regulated by their individual professional body. So for example, I myself, I'm a professional deputy and donee as well. So in addition to being regulated by OPG, I'm regulated by the law society as well, and I'm covered by insurance too. So these are the people that normally the particular institution would look to step into the gap if there are no next of kin.
Okay. Well, that's a great insight to that actually. Actually, then moving forward, let's look about the responsibilities of a deputy, because a lot of people might think, oh, I'm just taking care of that my loved one. How difficult is it? So, SK, can you tell us a bit about the set of statutory principles that bind a deputy?
Wow, great question. I think even before I touch on the statutory principles, I think the practical realities, right, of being a deputy, at least contrast with that of a donee, is firstly, a deputy is responsible for furnishing annual report to the Office of the Public Guardian, right, every year on all the personal welfare decisions, all the property affairs decisions that's made on behalf of the of the of the person who lacks capacity. There are some exceptions, right? So for example, you don't have to report, like this hawker meal that costs this chicken rice that you bought for the person for $5. There are certain things you need to report, some you don't. But I think the main point is that an annual report needs to be produced and submitted every year, right, for the deputy. So that's one big responsibility. And in order to submit a report, that means you need to keep very
Accounts.
good accounts. I'm not sure
Yeah,
all people keep good accounts. I'm not sure whether Regana keep good accounts, but
I do.
I leave my wife to do the accounts. So yeah, you suddenly responsible for the personal welfare, right? And also the financial matters of somebody else, including whatever investments that they have made in their lifetime. So in that sense, the responsibilities are fiduciary in nature, and they
Mhm.
are very 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 heavy lah in that sense, and should not be undertaken lightly. Yeah.
Okay, so circling back to the principles,
Yes.
if you could
Yes.
just share with us a little bit about the guiding principles that guide a deputy.
Yeah, so the deputies, right? Obviously, you need to use your powers judiciously, right? So you need to make sure that obviously some of the general principles we always need to act in the best interest of the donor. But what is best interest, right? So best interest essentially would be what would the donor do in that particular situation if the donor still has capacity, right? What would the donor do in that same situation if the donor still has capacity? It's not what you would do as a deputy if you suffer from the same situation as the person who less capacity, right? So often I tell my wife that, look, I love to eat char kway teow, you like to eat salad. Please, if I lack capacity, please continue to feed me my char kway teow, okay? So because that's good for me, that's what I would do if I still have capacity, right? So yeah, especially if she controls my pocket money, that'd be quite sad. But so that's one. You always need to act in the best interest of the donor. You also need to presume that they have capacity unless otherwise proven. You need to also, be aware that I mean, sometimes we make unwise decisions, right, in our lives, but also
Mhm.
unwise decisions do not always mean the person lacks capacity. Like if I eat char kway teow every day for breakfast, somebody might call me, crazy or unwise, especially my wife. But that doesn't mean I lack capacity, right? So you need to be very clear about what constitute unwise decisions and what is truly a situation where yeah, the donor, sorry, the person lacks capacity, like true capacity. So um yeah, I think at the end of the day, the deputy, or even for the donee, when you want to exercise your powers, you need to ask yourself a few questions. Number one, um, can the person remember the information, the facts that I give to them, right? If they can retain this information, can they hold it long enough to make a considered analysis based on this information, right? And even if they do, can they communicate lucidly, convincingly, and consistently, right? This particular action that they want you to take on their behalf, right? So if at any point in time you realize that there's a breakage in this chain of event, then it's highly likely that the donor may lack capacity, the person may lack capacity and may need your support.
Okay, thank you very much, SK. Now, from what in my research a little bit here and there, I know a deputy cannot make all the decisions for the person who lacks the mental capacity, right? Uh, I've heard of stories where people with disabilities have chosen their life partner, and they have a deputy. So, there are many restrictions that a deputy on the decisions that a deputy can make. So, if you could tell us very briefly, what are the restrictions?
Great question. I think first and foremost, even before you look at restriction, you need to see what you're empowered to do, right? And whatever you're not empowered to do, technically there are already restrictions. So the court order that empowers the deputy will lay out all the powers that the deputy will have, right? So anything that is not mentioned, even if it's not in statute, right? Even if it's not mentioned in legislation, they will be considered restricted activities that the deputy cannot engage in, right? But if we are talking about what are the express things that the deputy cannot do because it's already in legislation, obviously we cannot deal with marriage, right? You cannot help the deputy to get married, to divorce, to donate their organs, make an AMD, so on and so forth. Very personal liberty related issues. But you do, and it's not very well known to many people, you can help the person without capacity to actually apply to the court to make a CPF nomination if they have not made one, to apply to the court to ask them to help the person make a will if they haven't made one, right? So the deputies cannot make a will on behalf of the person who lacks capacity, right? We call them P. We call the person P. The deputy also cannot make CPF nominations or revoke, but it does not mean that they don't have the legal connection, right? You call it nexus to or local standby to apply to the court, to ask the court to make decisions on the person's behalf, provided it's in the person's best interest.
Okay,
Yeah.
so I think just to sum up about the responsibility of deputyship is always act in the best interest of P, as you said, and also keeping the quality of life of how P was before. And and when he or she loses a mental capacity, to keep that, like you in your char kway teow, hopefully. Okay, so speaking about AMD, and before moving on to the next topic,
Sure.
let's talk about planning in advance for your medical care, which
Sure.
we call Advanced Care Medical Directive. So if you want to make an early decision about your medical care in situations where you cannot express your wish, for example, if you have a major stroke, you can consider creating an advanced medical directive. Now, SK, could you share with us what is an AMD and who is eligible to make one?
Okay, so an AMD is a legal document that doesn't require lawyers. Right, you can only make it with a doctor. There you go, right? But I'm talking about AMD. So anyway, jokes aside, AMD is a legal document that can make to cover a very extremely narrow scope of medical treatment, right? In the situation where certain events crystallize or when certain factors crystallize. So for example, AMD only works in a situation where a patient firstly is terminally ill, facing imminent death, no hope of a permanent or temporary recovery, is in an unconscious state or unable to make a rational decision, right? So basically these factors plus the lack of capacity or unable to make a rational decision needs to be present, needs to be the consensus of 3 medical practitioners. 2 must be specialists, 1 must be the treating physician of the patient before it can be activated. And when it is activated, it only covers the situation whereby extraordinary life-sustaining support will not be applied, right? It only covers a situation where extraordinary life-sustaining support should it be applied or not. It does not deal with other issues such as, do you want CPR? Do you not want CPR? Right?
Oh,
Do you,
okay.
so it is very narrow in scope in that sense. it is also silent on what happens if a person suffers from brain injury, you know, and is in a vegetative state, because brain death to some people is counted as terminally ill, but not to others. So it's a quite of a gray area. But essentially, yeah, AMD is a document that you put in place if you do not want to receive extraordinary life-sustaining treatment. Basically, you're already dying. You just want to let the process of dying be natural, right? You don't want any life support machines, right, to artificially prolong your life. So that's essentially AMD, right? In theory. But the operationalization of an AMD is not so straightforward. So like as mentioned earlier, you need 3 physicians, right, to activate it. If there's no consensus among these 3 physicians, another 3 physicians, a panel of 3 physicians needs to be assembled, you know. And once these 3 physicians are in concurrence that they concur that, you know, all these factors are present, they will need to check with this registry in MOH on whether AMD has been made by this patient. The reason being that it's illegal for doctors and healthcare workers to ask the patient whether they have made an AMD. I think the policy reason is because people are afraid of accusations of harvest, you know, organ harvesting and so stuff. So they want to maintain some sort of propriety. So under the law, under the Advanced Medical Directive legislation, the doctors and other healthcare workers cannot ask the patient whether they have made an AMD or not. So you need to call this registry. And this registry, I heard nobody on this registry is the webinar, but they have one of the best work-life balance. So yeah, I suppose their working hour is like 9 to 5. You may be able to catch them, you may not. And we know that emergencies can happen anytime. So it's not very likely that you will be able to, it's not always likely that you'll be able to get the, you know, the staff, right, on the call all the time. And so what actually happens to people who make an AMD at the end of the day is that they will still be put on life-sustaining support more often than not. And then they will then have the life-sustaining support be switched off when the existence of a validly registered AMD has been established. So that's how it looks like, roughly operationally. Some people might think that it's a bit leceh, right? You know, it does not actually serve the purpose that it's meant for. But for others, you might think that, hey, you know, if I put an AMD in place, if I made my wishes known to my donees, right, through the LPA or to my loved ones, then the AMD essentially is to ensure that there is a consistent narrative, right? There's a consistent narrative that runs through your healthcare decision, your healthcare options. And I guess from a legal perspective, that's very solid evidence, right? You know, to say that this is really what you want to do, what you want others, you know, to do on your behalf.
Okay. Before I get to some questions, so would you advise doing the LPA and AMD concurrently, or how would you, what would you advise?
Okay, so in a nutshell, if you have made an LPA, the donee can make many medical welfare decisions on your behalf, right? Including what's covered under the AMD, right? So when you make an AMD, what you're essentially doing is to take the coverage under the AMD away from the donee. So the donee cannot make decisions that's covered under the AMD if you have put in place one. So at the end of the day, if you think that, I mean, if you want to save time, there's nothing to stop you from making an LPA and AMD concurrently. But I mean, you know, ask you to consider whether you do need the AMD, right? I have a few clients, they make their wills, they put their LPAs in place, they make their AMDs, and they also make this thing called Advanced Care Planning Workbook. And I think that is awesome. That is really awesome because from my perspective, despite the drawbacks of some of these systems, it's almost akin to total defense. Right? Like really total defense, you know, whichever way you look, it's easy to deduce what are the intentions of the donor or of the testator, and that's the most important thing. When the donor is unable to express themselves, what does he or she want, right? And we have to make inferences from these documents.
Okay, understand. An audience member actually asked for a clarification, SK. AMD will only be activated when a patient is already on extraordinary life-sustaining treatment or before extraordinary life-sustaining treatment has started. So when does the
That's a
AMD
that's
kick
a
in?
Yeah, so that's a great question. So by legislation, the AMD, the process, right, to really activate the AMD is really when that 4+1 factors is present, which I mentioned earlier. And that is independent on whether extraordinary life-sustaining treatment has already been applied or not. So basically, the patient, as I mentioned, needs to be diagnosed, right? Needs to be terminally ill, needs to be facing imminent death, uh, no hope of a temporary or permanent recovery, is in an unconscious state or unable to make a rational decision, right? Maybe in the midst of these factors, the patient may already be receiving extraordinary life-sustaining treatment due to a particular emergency, due to maybe they are in A&E and next of kin cannot be contacted. But I think, at least from the point of legislation, it uh, is not a factor that will trigger not trigger AMD in that sense.
Okay, I think there was another clarification also is stroke is not a situation where the AMD will be activated. I am assuming that depends on the severity of the
Yeah,
stroke, but Shenket, please do share your thoughts about this.
my thoughts are your thoughts, Regana.
Yeah,
So
I
I,
would
I
imagine
think
it's a severity, right, of
it's
the
really a
stroke.
severity, right? Like my dad had a stroke some years back, but very mild one. So obviously, I mean, he's not terminally ill, right? Thankfully. So obviously, AMD will not be activated, but we do have obviously very serious stroke patients that result in very bad impairment of the brain leading to a vegetative state, then that might be a different situation altogether. So yes, you're right, Regana. I agree with you. Stroke patients, their situation is fairly broad. So there might be situations where the four or five factors that I mentioned, in order for AMD to be activated to be present, but my sense is more likely than not, it will not be present. But I don't know. I'm just making a value judgment.
Understand, thank you. And one last question on AMD. Um, if AMD is made by the donor, the donees cannot overrule it, right? Uh, I
Um,
think you did answer that a bit just now, that if the AMD
yeah,
is made already.
I mean, I would love to give a textbook answer to this question, and just moved on. I mean, the A&D is made by the donor, right? When donor has capacity. So obviously, we need to presume that unless the AMD has been revoked, um, the presumption will be that whatever has been registered with the MOH registry will still stand, will still be the prevailing state of mind of the patient, even though the A&D may have been made 10 years ago, 15 years ago, right? But truth be told, at the end of the day, it's really up to the individual hospitals and it's really up to the individual healthcare practitioners as well. I understand that the doctors, I mean, the different medical institutions, they have their own SOPs on how to deal with patients with AMDs, because there's some moral philosophical issue behind it. Some doctors can opt out from not activating an AMD. That's why I heard. Some doctors may be in. So it really depends, right? Who's the treating physician at the point in time, right? Are they opt in, opt out, for example? And it also depends on, I guess, the needs of kin as well, right? Whether do they also have a consensus that they want this AMD to be respected, unless they have very strong opposite views, that they are very willing to challenge the doctor and sue the doctor in the hospital for if they activate the AMD, right? So I mean, there are a basket of factors involved, some legal, some non-legal involved, but back to the textbook answer. The textbook answer is the legislation empowers the healthcare practitioner to follow through on the AMD regardless of any objection if the AMD is validly executed. Yeah, so
Okay.
that's the textbook
Thank
answer
you
for you.
very much, SK. I hope that has shed some light on what AMD does and whether you're eligible to make one. So if you wish to know a little bit more about advanced care planning, you can visit the Ministry of Health website. So we're going to go quickly into something called wills. Now, a will always ensure, and which I have learned at very late stage in life, that your assets are properly
Oh yeah.
distributed according to your wishes upon your death. So it is quite important to know how to make a will. And I'm sure a lot of people will always ask you, do I need a lawyer as a witness? Do I need my friend? Do I need to bring my this and that? So SK, could you sort of like tell us what are the requirements for a will?
The requirements it's one of those big questions that sound like it has a very simple answer. It's one of those simple questions that sound like a very simple answer, but I guess at the end of the day, to make a will, you need to have the willpower to kickstart on the process, right? You need to be able to sit yourself down and do a stock inventory of your life. What station in life are you at? And yeah, what you want to do with the resources that you have accumulated. If you want to ask me about the formalities of executing a will, I would say leave that to professionals. Don't play with the formalities, right? I mean, whether is it finding independent witnesses or trying to make sure the wordings of the will are done properly, or to, so and so forth, right? I think what is probably a more important question for people who want to make their wills to consider is how do they want to plan their wills, right? So most Singaporeans that I've encountered, they do what I call asset focused distribution. So basically they say this property goes to A, the bank accounts go to B, or everything distributed to my children in equal shares, right? So quite straightforward. So that's essentially, I mean, yeah, you're basically you can make a will with this kind of intentions. So that's asset focus. How do you distribute a particular asset? The next level of will planning really involves the question, what sort of knowledge or values I want to pass down to the next generation, right? So then that will entail a different approach, because the giving needs to be seen from the recipient point of view as well, right? So I was just telling a client yesterday that he wants to give this landed property at Tanah Merah to his 25-year-old son. I was like, come on, you sure your son wants to live at Tanah Merah? You sure that your son doesn't want to get married and purchase his or her own HDB flat? I mean, his HDB flat, right? And enjoy all the things that a Singaporean wants to enjoy. So I think what may be a beautiful gift from the perspective of the giver, right? From the recipient point of view, it actually causes them more headaches and trouble than what is originally meant to. So I think if you are a first timer making a will, you can start from asset focused distribution, right? You can see who's more needy, who you need to support, right? So for example, property to your spouse, liquid monies to your parents because they're probably in need of more liquidity than a half share in the property, for example. But once you cross that stage of an asset focused distribution, then maybe you can think more about needs, right? And like values, like if you don't dump all your assets onto your child or onto anybody else when you're still alive, why will you do so after you pass away? Through a will, right? So stagger the distribution, put down certain conditions, maybe create some projects for them to be involved in, so on and so forth. Yeah, so my answer to what seems like a relatively simple question.
Okay, thank you very much. So, quickly going on to what is or what should go in a will. I mean, everyone has a shopping list, right,
Yeah,
of
yeah.
what they would like to give away. So, in a nutshell, Shenket, what like insurance policies, property, what should one look for or put in their will?
Okay, I think maybe I'll rephrase the question like what is covered under the will, right? So if you're talking about
Sure.
coverage under the will, well, there are some assets that can be distributed by will, some you can't, right? So for example, CPF monies, right? You need to make nominations. It cannot be distributed via a will. CPF monies have statutory protection. It's protected from creditors and from bankruptcy of the CPF members. So in that sense, it's distributed via a separate mechanism protected by certain laws. So which means a will cannot deal with CPF monies, right? Will also cannot deal with insurance policies with nominations, with valid and active nominations. All right, so I qualify by saying valid and active because maybe your nominee has passed away, right? And because your nominee has passed away, there's no valid nomination. Provided it's what we term a revocable nomination, then the insurance proceeds will then flow into a will for distribution. If there's a valid and active nomination at the point of passing, then the proceeds of that particular insurance policy will not be covered under the will, right? And the next, I suppose the next asset will be jointly held assets. Even though this is a bit more complex, a bit more contentious, jointly held asset, the general principle that everybody will know will be that the surviving owner gets to inherit it, right? Whether is it property or whether is it bank accounts. But the current state of law is not so straightforward, right? In the sense that if someone disputes the ownership of the joint account, they could say that, you know, the money is this joint bank account, 90% comes from A, and the understanding is that B is supposed, owner B is supposed to hold it on trust for A, right? So even if you put, even if you never put it inside the will, it might be a situation where this particular joint account and the contents inside and the money inside can be covered as well. So yeah, my at the end of the day, my position, if you're unsure about what is covered under the will, do go and seek legal advice, right? And they can figure out the coverage. Besides obviously dealing with what we call movable and immovable assets, so there will be immovable assets be your properties, movable assets be your cash, your stocks, and so on. You can also use a will to deal with your other sentimental items of sentimental value. So in my case, my grandmother gave me a gold ring, right? In her will when she passed away at a grand old age of 91 years. So I think because she wanted me to use the ring to propose to my now wife, then girlfriend, and she probably want to say that if you don't propose to her, I'll haunt you forever, kind of thing, right? But she didn't, thankfully, because she's my wife. So anyway, so you can use it to deal with sentimental stuff, right? If you're of Merdeka generation or Pioneer generation, you probably have hard copy photographs rather than digital, right? Or family time the kampongs, so and so forth. Who to deal with all this? I would call that family heirlooms. So you can also specify in the will as well, among many other things. And that also, you can also do funeral arrangements, so and so forth. Yeah, actually the coverage is quite unlimited. It's really up to your imagination, up to what are the laws that applies to that particular asset.
So it's like a shopping. It can cover anything. You can put as little as you want, and you can put as many as you want, and to as many people as you want to distribute to. But just to remind everyone that CPF savings are not covered by the will.
Yeah,
that's correct.
Very
okay. Very quick question though.
Can I just quickly raise a point as well?
Please. Yes.
So on the part of CPF, right, some of you who are below the age of 60 years old, you may have a valid and existing CPF dependents protection scheme, right? So do note that your CPF nomination does not cover the nomination for your CPF DPS, even though there's a word CPF in front, all right? And the nomination also do not cover certain types of assets that you purchase using CPF monies too, all right? But what you need to know is the monies in your OA, SA, retirement account, what's not, they are covered by nomination. That's the baseline. Okay.
Okay, thank you very much. We have a question from a attendee. Now, if a house is co-owned, can or what's written in the will by one of the ownership override the co-ownership?
Well, firstly, we need to see what sort of co-ownership, right? Is it because this term co-ownership has been used quite loosely in recent times. Co-ownership can mean joint tenancy or tenancy in common, right? In both joint tenancy and tenancy in common are legal concepts where at least two people's names are on the title deed, but the manner of holding between at least these two people, they are different, right? So under joint tenancy, A and B both own 100% of the property, if I may put it that way. Both A and B owns 100% of property under joint tenancy. So the general principle of survivorship will apply. That means when A passes away, B will inherit outright A share and vice versa. Whereas if it's a tenancy in common, A and B's name are both on the title deed, but the share has clearly been delineated. So the share could be 50-50, right? Or sometimes maybe you want to buy a property with your spouse, you want to use your spouse's CPF to to get a mortgage, I mean to pay for the property, right? And to get a mortgage. So you maybe give her like 1%, right? So it could be 99%, 1%, kind of situation. We've seen all sorts of different types, but that's tenancy in common, right? And because under a tenancy in common, or what we term TIC for short, the share has been clearly delineated. So in a will, you can give away that clearly delineated share to anybody that you want, right? Whereas for joint tenancy, the shares are not clearly defined, right? In that sense, because both A and B owns it outright, like both A and B owns 100%. So you can't use a will to terminate a joint tenancy holding in Singapore. I repeat that again. You can't use a will to terminate a joint tenancy holding in Singapore. You may be able to do that in other countries like UK, for example, but I can't do it in Singapore. If you want to terminate a joint tenancy holding and distribute it in any way that you want by the will, you need to sever the joint tenancy. And there is a legal process to do that.
Okay, thank you for that clarification. One last question on wills. If funeral arrangements are included in the will, is a grant of probate required before the funeral can be conducted?
Okay, so I know I mentioned earlier that you can put funeral wishes inside the will, right? But that's also, I say that, with the assumption that when the will was made, the executors are informed of the contents, the beneficiaries also know what's going to happen, and that includes the funeral rites as well, right? I think with regards to funeral rites, you should really just tell your next of kin, what you would like them to do on your behalf, rather than to put it in your will as the only means of informing them, right? I say that because I did have a situation where a client said that he wants to be buried. I ended up being cremated and a sea barrier because out of respect, the beneficiaries did not open the will until, the executors did not open the will until the person passed away. Until the funeral rites were over, So you cannot violate the process, right? You cannot, you cannot reverse the process. So I would say that specifically with regards to funeral rites, do inform your next of kin or loved ones how you would like it to be done. If you foresee a potential contention on what sort of funeral rites that they will do on your behalf, then you make it even clearer by stating in your will. So your will should be seen as a backup to making your intentions clear regards to your funeral rites rather than the main document itself. So in this connection, the grant of probate or the question of whether you need an extra grant of probate is not really relevant if we look at how things actually play out in reality. Yeah.
Okay, understand. Thank you very much, SK. So I hope everyone understands a bit more on how to make a valid will and what goes into a will, what does not go into a will. I would highly suggest that, as young as 21 to think about your future and writing a will. And please, SK, correct me if I'm wrong, if 21 is too young. But however, what happens when you die without a will? You forgot, or you just didn't want to write a will, and you've got all this property and assets. So what happens? And we've got to sum it up quite quickly because we have a scenario coming up and lots of questions. So
Right.
what happens, SK?
Great. So generally under intestacy, which basically means, well, broadly, it means that when a person passes away without a will, you may have heard of the term intestacy laws will apply or intestate laws will apply. It basically means that a set of laws created by our government will predetermine who are the beneficiaries and what percentages, right, of the deceased estate that they will get to benefit from. So that's in a nutshell, very quick summary of intestacy. But the intestacy laws can have added layers of complexity based on the family tree, right? Are there legitimate, illegitimate children? Are they step siblings, right? Are there more than one spouse? You know, is the person a divorcee, right? So then this will complicate the family tree, and then the intestacy laws, when applied to the family tree, the outcomes may be very different from your expectation. Where when you look at the family, when you look at the intestate laws yourself. There is also this concept called partial intestacy. That is when there is a will being made, but the will does not cover all the assets in the person's estate 100%. So for that particular asset that is not covered, it will fall under intestacy laws as well. So that can happen even with a will. So that's what we call partial intestacy. A very quick example, A gives something to A, say if I pass away, I give all my assets to B. If B passes away, then I give everything to C, right? So let's say B and C both pass away before A, you know, and A never make a new will, never specify, then technically the will, a big part of the assets will fall under intestacy laws, right? Partial intestacy in that sense. Yeah.
Okay, I actually just very quickly one question actually. So, how different is it in making a will for a Muslim? So I'm not sure whether you'd be able to actually answer that because I know the laws are a little bit different.
So for Muslim Singaporeans, like Muslims domiciled in Singapore, right? Then Singapore laws on distribution will apply, right? And our current laws for Muslims, you have this concept of the Faraid concept. The Faraid in plain English terms, I would call it forced heirship. Forced heirship meaning that a predetermined set of beneficiaries regards to your estate is already decided. You can't change that, right? So it's almost akin to intestacy laws in that sense, you know, right? Because the beneficiaries are decided for you in advance, except that for Singaporean Muslims, their flexibility to get out of this forced heirship is a lot more constrained than the non-Muslims. You can make a wasiat, right? You can make a will, but then the contents of the will be valid insofar as it does not contradict the Faraid distribution. And by our law, by the Administration of Muslim Law Act, you can give up to 1/3 of your estate away to non-Muslim clients. I mean, sorry, to non-Muslim, to non-Faraid members. Having said that, remember we said earlier that certain assets cannot be distributed via will, for example, CPF nomination, right? So that is a way that people use to do more targeted giving outside of the slightly more forced heirship rules, like Faraid concept under our laws. There's many things to talk about in this area, but I will just leave my answer
Another
at this point.
webinar on this. Thank you very much. So, we have a quite number of questions. So we're gonna just jump into one scenario, SK. Let's talk about Adam. And let's spend about 5-10 minutes talking about Adam's scenario. Now, Adam is 35 years old, and he's working. Great job. And he recently got married, and he has no children. He purchased a HDB flat with his wife and is paying off his mortgage or his loan. Now, in your professional opinion, what should Adam be considering at this stage of his life? You know, he has no kids, he got married, lots of responsibilities.
I mean, first and foremost, I think Adam has a responsibility to his wife. So he should make a lasting power of attorney first. I think the lasting power of attorney will buy him more bandwidth and more running space, more breathing space to do his other parts of estate planning. So with the LPA, he should ideally appoint his wife, right? Because if something happens to Adam, right, let's say he met an accident, right, and is incapacitated for a year, right? He may recover after that, but he's incapacitated for a year. He lost mental capacity during that period. He may have some insurance policies, right? But in order to cash out those insurance policies, he will need an LPA, right? The wife will need an LPA to do that. He probably would also need an LPA to trigger whatever mortgage insurance, right, that he may have purchased. If you never purchase a mortgage insurance, his wife probably if they can't afford the premiums, I mean the monthly repayments, they probably will need to downsize, right? So if you need to downsize, then Adam's wife will need to have the power to represent Adam to sell the house, right? So in that sense, I very clearly I will recommend lasting power of attorney as the first instrument to be put in place for Adam.
Okay. At the age of 35, so
At
he
the age of
should have a. Okay.
I'm
So
younger
let's
than
say.
him. Start LPA in place already.
So this, I should really consider that. So now let's say moving 3 years, fast forward 3 years, Adam now has a daughter and she is a child with special needs. Now, how can Adam ensure that his daughter is well provided for? How can he better plan to meet um, her future's care needs in the event he passes on or his wife passes on?
Great question. So I think first and foremost, still the same thing. Put the LPA in place, right? You want to make sure that whoever is the main caregiver for Adam and also for Adam's special needs child, that particular caregiver will have all the instruments and tools at his or her disposal, right? In this case, at her disposal, to carry out the caregiving responsibilities and duties. I mean, it's really so difficult to be a caregiver, much less if you don't have the appropriate tools to carry out, the responsibilities. But with regards to the LPA, maybe I may suggest to Adam to actually make a LPA Form 2. As it currently stands, the LPA Form 1, as I mentioned, wow, way earlier in this webinar, that a donor use the LPA or a person make an LPA to appoint a caregiver to use his or her own resources to take care of himself. The main idea is the main beneficiary of the LPA is really the donor. It's not the donor's family. It's not the donor's children, right? There is a clause within the LPA Form 1 that gives some discretion to the donee to make gifts to other parties, right? But it's not, in my personal opinion, I don't think it's very well defined. And I think there is a difference between making gifts and providing maintenance to the kid. So I think LPA Form 2 in a sense will give flexibility for Adam to specify the various maintenance needs, right, of the child and ensure that whoever is his donee, it could be his wife, it could be the replacement donee for his wife, right? Because you also don't know what may happen to the wife. Will carry on the instructions of taking care of the child if anything happens, right? If Adam had purchased insurance policies, that's fine. The LPA can deal with them. If he prefers to make nomination for the kid, I mean, to direct nomination of beneficiary, that is fine as well. It's a matter of preference and a matter of organization. Right? Sometimes if you don't make nominations, you know that everything will come into one pot, right? Everything will, all the process will fall into one pot, and it's so much easier to manage. If you make nominations, you might not keep track. Beneficiaries may pass away, so it's very difficult to follow through. And then probably
Okay.
should also make a will, right, to bless his wife with all his assets, and also to, in the event where his wife passes away, then to his child. I say this based on assumption that the wife will obviously take care of the child, right? So there's no reason why you should split the asset between 50% to the wife and 50% to the spouse. I mean, sorry, 50% to the spouse and 50% to the child. You should make sure that the wife is taken care of so that the wife can take care of the child. So I would say 100% to the wife and maybe 100% to the child. And to appoint some guardians, so that in the event both parents pass away or lack capacity,
Yes, I
someone
was
can
just going
come
to
in.
ask you that.
Yeah, someone can come in and deal with the guardianship duties, all the legal formalities of bringing out the child. And I think when there's a minor beneficiary involved, especially one that lacks mental capacity, the court is, for lack of a better word, very anal about what sort of trustees that they appoint and executors that they appoint, to manage the assets on behalf of the child. They will ask for a lot more documentation. They will ask for administrative bond that equates to the size of the estate to be furnished. So if the HDB flat is worth $500,000, there's an insurance policy that pays out $500,000. Who is going to be able to volunteer to take on this role of an executor / administrator and still have to bear financial responsibility for.
So then my
punishment.
question to you is, if would it be easier for them to leave it to a trust, for example, SNTC, right? Special Needs Trust Care.
Yeah.
In the event both parents, God forbid, something happens, and for them to do a bit of a pre-planning, would it be better for them to get a trust?
That's a good question. I think situations that involve special needs children, which is my area of passion, it's generally a bit more complex. We generally don't use one singular tool to deal with their issues. That tends to be a hybrid of options they put in place. So it could be a will LPA together with maybe a special needs trust, company supported trust, plus a deputyship involved, right? So it could be a hybrid of things. Or sometimes you may just have a deputyship but no special needs trust. So it's too much details to get into on how these different instruments relate to each other. But I agree with you that SNTC is definitely an option. Though the limitation of SNTC or special needs trust, company trust, is that they don't deal with immovable assets like property. So let's say Adam's child, is high functioning, right? Even though if intellectual disability is high functioning and functions best in a place of familiarity. And the idea is Adam wants the child to continue to stay in this flat insofar as practically possible so that he still can be as independent as possible. SNTC trust will not be helpful because they cannot manage this property on behalf of Adam's child. So there needs to be other solutions to be put in place, which exist, but requires further exploration that we don't have time for over here.
We made another webinar to just speak about Adam's family matters. But
Adam's family.
yeah,
Sorry.
okay. So thank you very much, SK. It was a very informative session. I have so many questions and we only have 10 minutes. So I really do want to get to the questions for our participants. Now, let's go to the first one. And it's going to revert back to some of the things that you said at the beginning of this webinar. Now, having a will in terms of having an executor is not the same as having an LPA, right?
Yeah, it's not the same. It's not the same. I mean, firstly, you really need to get concepts right. A will, right? In Chinese, you have this concept. You plant a tree, but somebody else enjoys the shade. You plant this seed, it grows into a tree, but somebody else enjoys the fruit. That is really the concept of a will. You benefit someone else, right? Somebody else gets to enjoy your hard labor. But a LPA is really for your own welfare. It's really for your own good. It's to use your own resources to take care of yourself, right? And to ensure that your personal autonomy is respected even when you are unable to make a decision for yourself because you give advanced instructions to your donee. So that's an LPA. Whoever that you appoint as your donee at LPA may not automatically become your executor, right? Because they are different roles and responsibilities. I have some clients who tell me that they would entrust their wife with personal welfare decisions, but not necessarily financial matters. So and being an executor entails a very different requires a different set of skill sets as well. So you cannot take for granted that whoever that you appoint as a donee is suitable to be your executor, right? And that the appointment will also happen automatically because nobody can read your mind. You still need to put the identity of these people down in the respective legal documents.
Okay, thank you. So next question. If my spouse suffers a stroke and became mentally incapacitated, as well as total permanent disability or TPD for short, do I have to apply for deputyship in order to claim the Insurance Dependent Protection Scheme? If yes, does it mean that the insurance payout can only be used for my spouse's caregiving and well-being as opposed to being used for his children's education?
Yeah, first and foremost, if this scenario is true, I'm really sorry to hear about it.
Yeah.
Do come across this quite often in my line of work. The short answer is yes to both questions. You will need a deputyship to get the CPI DPS out. But the good thing is the government has recently, or the court has recently introduced a fast track method of obtaining a deputyship order if it's for very simple matters like obtaining insurance policy monies that is not more than $60,000, for example. So obviously, this 60,000 is targeted at CPF DPS because normally it ranges between 42,000 to 56, 58,000 plus the bonus that they will give. So yeah, so that's an easier way to get this order out. But the bottom line is you still need a deputyship order because the banks, the insurance companies, they will want to know who can I transfer my liability to, when I when I make this check to the beneficiary, right? The second question, right? Can it be used for the children's welfare? It's a really difficult question to answer. I mean, the short answer is yes. No, the short answer is no. It cannot, because the money is meant for the spouse's welfare, right? But it can be argued that sometimes what is in the best interest of children, the spouse will also want the welfare of the children to be taken care of, which makes the situation a bit more tricky, right? Because it's not so gray anymore. So so I would tell you that the textbook answer is no, you can't, right? I guess that's publicly speaking, that's that much lah I can say. Though I want to take opportunity to flag out why then an LPA Form 2, if the person still has capacity, is so important, because you can then state monies explicitly that belongs to the donor can be used for the children's welfare, which is something that a deputyship may not always be able to achieve.
Okay, we're gonna take one more question before we wrap up, and I think it sometimes it happens to a lot of people. The question is, if I have no trusted person around me to execute my will, what other options does this person have?
So I mean, obviously, I would love to interact with this person, right? But my first question would be why there's no trusted person. If you have a particular beneficiary, let's say it's a person, and the person is of age, will you be able to consider the beneficiary as the executor, right? Because my personal view slash 50% professional view is that the beneficiary has an incentive to make sure that estate is well managed. So it might not be a bad idea all the time, right, to appoint a beneficiary as an executor as well. If let's say your beneficiary is a charitable organization, maybe you can approach the charitable organization to see if they are willing to volunteer someone, right, to be your executor. So this role can be done on a named person basis or in a named capacity basis. So in a named person basis, that would be I appoint ABC of this charitable organization to be my executor. So that is on a named person basis. You name exactly who you want in the organization to be your executor. You can also name based on capacity, right? So capacity will be, I will want a director, someone who holds the position of director in this charity organization, or someone who holds the position of treasurer in this charitable organization to be my executor. So that is naming the position, not naming the person, right? So some law firms, they also offer executorship services, but you also need to make sure that, I mean, law firms are also managed by humans, by myself, right? I mean, I'm flesh and blood, I can die anytime. They do also offer executorship services. That's also a potential solution as well. Yeah.
Okay, so SK, 1.5 hours just flew by.
Is
Thank you
it?
very much. Yes, we have to really bring our Q&A session to a close. Just a reminder to all our participants who attended today, thank you firstly very much for coming. Please
Thank
do
you.
not forget to download the resources. You still have time to download the resources that we have the OPG guide, the deputyship guide, the donee guide. Please, again, they can be found at the files tab. So we hope you found our webinar on advanced legal planning useful. At least I did, and it was nice to see SK here again. Now, your feedback
Sama-sama.
will be your feedback will help us make future webinars more relevant and useful to you. So once you leave today's webinar, you will receive a survey. So please, we really appreciate your feedback on today's session and how more or how better we can improve for our webinars, future webinars. So SK, once again, thank you very much for spending
No.
time with us.
Thanks for having me,
And
Regana. Thank you.
thank you very much, SK. You're welcome, actually. And to all our participants, on behalf of Law Society Pro Bono Services, thank you for joining us today.